Hello, this is the fifth in a series of pensions law technical bites, a series of short webcasts looking at the new provisions under the Pension Schemes Act 2021, most of which is not yet in force, but will be coming into force. My name is David Pollard. I'm a pensions lawyer at Wilberforce Chambers and a barrister. This is the fifth in a short series, probably the last one. I'm giving this on the 5th of August 2021. What we're looking at is that fifth, continuing on this series of short webcasts looking at particularly the fines and crimes, new penalty provisions that are going to come into force under the 2021 Act by way of insertion into the Pensions Act 2004. So in particular, looking at this one on information to trustees. Now, these webcasts are just discussions. They don't take the place of advice. They're intended mainly for professional advisors, partly because I can't think who else would want to listen to them. But if you're not a solicitor, then you should get legal advice from a solicitor. And if you are a solicitor, you should consider formally instructing a barrister. It's new legislation. There's no case law on this. Some of the provisions look similar to other provisions, so we can draw stuff by analogy, hopefully, but we'll have to see how everything's going on. Much is going to depend on the facts of any particular situation. And because we're talking about penalties levied by the Pensions Regulator, TPR, much is going to depend on what TPR thinks of a particular situation, what its policy is, which we don't necessarily yet know. So what I'm looking at is financial penalties under Section 88 capital A of the Pensions Act 2004. It's a new section going to be inserted by the Pension Schemes Act 2021. And that broadly gives a power where it's applied by legislation. So where there's a reference to this section, for the regulator to issue a notice requiring someone to pay a financial penalty. And that's up to £1 million. So quite a big chunky number. Hopefully only extreme cases would it get that far. And it will need to go through the usual process before the regulator does that. So there need to be a warning notice issued to the person. Then there's a decision by the determinations panel of the regulator, and there's a statutory right of appeal or rehearing before the upper tribunal. So if someone does an act which is within one of these sections, an act for this purpose includes omission, then this penalty can be levied. Now there are seven sections that deal with, that refer to Section 88A. So the new provisions added in by the 2021 Act. 4 of them are sort of criminal and financial penalty sections. So the regulator will have this choice about, do I want to do a criminal prosecution or do I want to do a financial penalty? And then there are 3 which are just financial penalties. So focusing on, in particular, Section 80B, which is providing false or misleading information to trustees or managers of an occupational pension scheme. We'll come on to that. There's also notifiable events in that sense. So it's more likely that these financial penalties will arise in the cases where there isn't also a criminal provision. So if somebody does something wrong, the regulator decides it wants to act, it can do it through a financial penalty in these cases, not a criminal prosecution. So the question is, has a person, so it's any person, knowingly or recklessly provided a trustee or manager of a scheme with information which is false or misleading in a material particular? And then did you give the person providing the information intend or could reasonably be expected to know that the information would be used by the trustee in their capacity as a trustee of the scheme? Only applies to final salary schemes, money purchase schemes. It doesn't apply to. There's also provision that some schemes can be excluded. There are some specific provisions, specific information provisions applies to, like insolvency practitioners giving notices to trustees and employers and auditors and actuaries disclosing information, and trustees giving information to another set of trustees. There are very similar provisions relating to the giving of information to the regulator. That's already criminal, and there's going to be a new financial penalty for that. And to the Pension Protection Fund. It's a crime, no financial penalty for the Pension Protection Fund. For giving information to trustees, it's not criminal, it's just a financial penalty. This sort of wording, knowingly or recklessly giving information which is false or misleading in material particular, is in quite a lot of other legislation. Now that's other legislation, but there may be some look through across on the meanings and things like that. I did a search on Westlaw, and that gives 154 hits for that particular phrase. So there's a lot of legislation out there that uses this wording. Interestingly, the Competition Act 1998, first giving information to the Competition and Markets Authority, that has another provision talking about, well, if you give information to someone who then gives it to the CMA, and you know they're going to give it to the CMA, and you knowingly or recklessly think it's false or misleading, then you can be liable. So it's sort of extending beyond, but that's not there for this, the one we've got in here for trustees. So it's anyone giving information. You've got to be the person who provides information. Now, who provides information? Is it the person, is it the agent who does it? Is it the post office? Is it, if you post it, there's a question about who provides. Does an employer provide information through an employee or through an agent? And who do you have to give the information to in order to be giving it to the trustees? If you give it to the pensions manager, if you give it to the trustees' lawyers, if you give it to an actuary or an auditor, they might or might not pass it on to the trustees. They might use it in terms of providing stuff for the trustees, like doing a valuation or something like that, but they might not actually pass the information on. So have you given information then to a trustee? These are all sort of difficult lines that are going to have to be worked out on a case-by-case basis through cases as it comes through in the future. So it's knowingly or recklessly providing information which is false or misleading. So I think if you knowingly provide information which is false, so you know it's false, that's fairly nasty down the end. So it's probably fair enough that there could be a penalty for that. Recklessly providing information which is misleading, probably the other end of the scale. Is that going to apply then? That could apply. What's reckless mean? Look at criminal cases, it's knowingly taking a risk, or a risk is foreseen as probable or possible or something like that. But lots of things you do can have risks. Driving a car could have a risk of causing an accident. Giving a set of accounts could have a risk that actually the accounts aren't misleading. Hopefully not, but there is a risk. Who's taking the risk? Well, the person providing it's knowingly taking that risk. But is that really misleading in a material particular if actually the recipient, the trustee, knows that the information could be slightly misleading? So do you have to know it's really false? These are all sorts of issues that are going to need to be brought out in legislation. Case law. Material facts can be your current intention. So who actually provides this sort of information? Employers, parent companies, that sort of thing. The member provides information to the trustees, how old he or she is, whether or not there's an ill health pension. Is their member actually ill or incapacitated within the definition? The member's doctor might provide information which the trustee would use. So that, if again, you'd hope it wouldn't be false or misleading information, but there might be some recklessness in now. Are you describing the risks? Is that enough? Lots of other people could provide information, investors, where the trust has an investment, companies that do that, insurers and fund managers dealing with trustees, they might provide information to trustees. Public authorities provide information to trustees. Hopefully they're not knowingly false or misleading. What about journalists? Journalists write an article, that's providing information. Do they intend it to be provided to trustee? Well, in relation to their functions, perhaps that's getting a bit remote. Journalists might find it more difficult to say that they weren't taking a risk of it being misleading, because that's an indication of this standard of care that this particular provision is getting at. So what happens if you suspect that information is reckless? It's very difficult. What about the context in which it's provided? So it's all necessarily a difficult area. It remains to be seen how the regulator will actually react. So it could well be watch this space, but take care when giving information to pension scheme trustees. So that was the last in the seminar. Slides are up there. There'll be a link on YouTube. There's a longer version of this talk if you're an APL member that was given to the APL last week. Thank you very much.